Well, good afternoon, everyone, and welcome to the first of our ARAG series for our broker network. We've still got a couple of people popping in, but I think it's always good to start on time and get things moving. So thank you for everyone who's joined us from around the country, and hi to all our Victorian brokers that have come on board. It's I know you guys are doing it tough, so we're thinking of you. Today's webinar will address a broad range of employment challenges that businesses are facing at the moment and that they'll face in the coming months. And ARAG specialise in legal expense insurance, and we think it's quite timely that we start to have some education and discussion around how we can support not only our brokers, but how we support your clients as they move and navigate through this really challenging time. So today we'll cover quite a few topics related to employment and employees, and we'll include some worker health and safety discussion and considerations and requirements that as we start to bring staff back to the office, what are some of the things that employers need to be mindful of, and what are some of the considerations they need to ensure that they're protected from a legal perspective, but also that they're doing the right thing for not only their business but for their employees. As it is something that nobody's experienced before, so some of this stuff there are no rule books for, and making sure that we get the right guidance and the right counsel is always so important. So I'm joined today by Jack Corry. Jack comes from one of our panel lawyers, and they support us in many aspects of our business, but also our clients. So welcome, Jack, from James Tuite and Associates. Jack has is a solicitor and has a law degree and an arts degree from Macquarie, which we were having a chat earlier about, which is quite a nice combination. So he's not only a proficient solicitor, he's also a creative type. So nice to have you here, Jack, and thanks for joining us.
Thank you very much.
So it's pretty informal today. We hope that you can ask questions as we go along, and like all webinars, there are a few different things to be mindful of. We've got the put your hand up if you want to have a question. There will be a time at the end that we can ask questions, but you can also use the chat function. So it's pretty casual around that sort of function for today's webinar. So I think what we might do is just get straight into it. So just a little bit about ARAG for those that haven't known. My name is Natasha Gale. I'm the General Manager here. Legal expense insurance is something that is really an exciting product to hit the Australian market. It's a European market product that is it's taken up quite a lot in not only from an employment perspective, but across everyday life for most Europeans. So bringing it to Australia is a really exciting venture for us here, and yeah, we're really excited to be part of the Australian market. So Jack, I think first thing we might just jump in and just talk a little bit about obviously COVID and the challenges that has presented for most businesses, not only those that are continuing to operate, but those that have had to shut down for various reasons. Can you just a little bit about JobKeeper has been extended, and there's been a lot of support through the federal government with JobKeeper, and I think that's been a really a good thing for the business and the economy. But what employment challenges do you think this will have as businesses move forward, and what sort of things do you think that we need to be prepared for, or employers need to be prepared for when this can end?
Yeah, well, the question we're kind of getting a lot now, we're hearing in the media, is what are we going to do when the tap turns off, per se? So when that government support finishes, what can we do? Are we going to be able to keep paying our staff, etc.? What is key for employers at the moment is to start planning now for when that scheme finishes. So for businesses that have joined up to the JobKeeper scheme, the employees that they've reduced their hours, once JobKeeper finishes, those reduced hours can't operate anymore unless there's the consent of of the employees. So you've got to kind of realise what your exposure is now. Will you be able to keep paying these staff, or will you have to let these staff go? So businesses want to avoid large-scale redundancies, just to the immediate financial impact that those bring. So you've got to start having those conversations now, whether or not you can approach your employees and say, look, JobKeeper is going to end in January or February. Can we keep you on reduced hours to ensure the viability of this business and your job? So the key is to start preparing now, having those conversations, trying to work out your exposure if and when JobKeeper does cease.
Yeah. So do you think it's something that employers should be getting some sort of advice on at this point? Is it too early to be doing that, or is it something that they need to be having conversations first and then maybe getting, or?
Well, first it starts, in an internal conversation with, the higher ups, the management, and going through, your staff, your wage bill, seeing whether or not you'll be able to continue operating, but for sure, seeking professional advice, whether, from a legal perspective, how you can kind of change these conditions in your contract is definitely helpful.
Yeah,
sure.
And I think that's a real challenge for a lot of businesses who have. I think everyone was quite willing to do and to be quite adaptable without too much formality around their workplace conditions.
Yeah.
But I think, as you said, as we start to go back, so a really important message to make sure employees start to do that planning.
Yeah, for sure. And for the most part, employees will be forthcoming because they want to see the business keep going. They want to, and they also want their job at the end of the day. So most of the time they will be, if you're forthcoming, if you're open and honest about the way the business is going. Mm-hmm. But obviously you will get some employees that don't want to kind of contribute that way, and that's when it becomes a decision as to whether or not you can keep them on or whether you're going to have to let them go.
Yeah, and that's probably at the point that you'd be looking for some guidance and some advice.
Yeah, for sure.
So that's probably a really good segue into, as they slowly return to the workplace, what are the obligations that companies have to provide in a COVID situation, providing a safe environment? I mean, I hear there's restrictions about how many they can have back in the office. There's restrictions about, can you make an employee come back to the office? These are all the sorts of things that seem to be popping up. What's your view, or what's your advice to employers as they try to navigate that?
Well, employers have a primary duty to make sure that their workplace is safe, as reasonably possible. So you're never going to have a workplace that's totally impenetrable to COVID, because it's impossible. But employers should already have, or should put in place a COVID plan. There's an abundance of information at the moment available through government and other agencies that give an idea of what should be included in the COVID plan, and we see it all around the place. I signed in today when I came in. Social distancing, hygiene practices, cancelling large-scale meetings, client interaction, keeping it virtual. It's essentially, you just want to make it your employees comfortable to returning to the workplace. Yep. Now you talked about restrictions. Employers, it's an implied or usually an express term in contracts that employees have to abide by the lawful and reasonable direction of their employer. Mm-hmm. So that's what it comes down to. If you're directing someone to come back into the workplace, is that a lawful and reasonable direction? That's guided obviously by government and medical advice, but also just a general feel. I suppose, I know that's not precise, but if it's just your employer doesn't want to come in because she's a bit worried about getting on the bus, the employer would be within their rights to come in, because that would be a lawful arrest.
So I think that's the sort of, I think they're the sorts of things that are really troubling from the employers that I've spoken to, is that, you know, they're trying to get their staff back, and, you know, I don't want to catch the bus, I don't want to catch the train, or, you know, I like working from home, and so there's this, so are employers within their rights to say, look, you know, we think getting back to business is important, and
well, for sure, it needs to be taken on a case-by-case basis, and as I said, based on, you know, the medical advice of the day or the government advice. But employers, if it's a lawful and reasonable direction, employers are well within their rights to, as long as, you know, the workplace is safe, you've got to go clean and safe, everyone's social distancing, etc. You know, abiding by government directions, then employers, in our view, employers are within their rights to.
And is there a formal notification around that? Does there need to be some, you know, if you were to say, look, okay, we're getting back, we need to go back, these are the things where, you know, Gladys or, you know, Andrews or Virgil and the rest of it, you know, we need to get back and we want to start operating again. Is there a legal requirement for employers to notify staff, to say, look, these are the things that we're doing? Or is it just a matter of, as of next week, we're back in the office and off you go?
Well, in terms of whether there's a legal obligation, probably not, but we're finding that businesses that are regularly communicating with their staff as to where they're going, so, you know, this week we'll be doing this, you know, week, are always in a better position, and the employees are more you know, willing to.
So communication is a key part of that. I think, and I think most employers are doing. I mean, we're going to talk a little bit about case studies later in the webinar, but I think there's some things that are happening there. So many businesses have long-term employees, or there's and employees that maybe have started in a different role and moved through various roles within the organisation. How often should a business review employment contracts where maybe there's been little or no change to the job requirements, there might have been a slight change, so it's not like, you know, oh, we've promoted you and you're now a more senior person, and normally you would get a new contract. So we had a question a few weeks ago where, you know, someone's been there for long term, 5 years plus, and only had like a 2-week notice period, yet didn't realise that they were quite a senior person by the time they kind of resigned. So through COVID and obviously these changes that we're making within businesses, work times, places where you work, where's your principal place of work, is it something that employers should be doing?
Yeah, I think we come across this a lot where businesses come to us and ask to review, draft a contract, etc., where the contracts across the whole company are so inconsistent. So there's some back from, you know, 1980s, some.
I wasn't born then.
You know, some.
No, you actually were.
Yeah, some, you know, drafted 2 weeks ago, some drafted by another law firm, you know, 1 week ago. We always say that they should be consistent, at least across, you know, the levels of employment, so executive, non-executive, and casual, part-time, etc. Because otherwise, as you said, terms, you'll be surprised at how many little tweaks to contracts, employment contracts, that need to be made as a result of, say, court decisions in that year or Fair Work Commission decisions. So businesses should really get in the habit of reviewing. If they have inconsistent contracts across, they should, you know, get the consistent contracts drafted, and also be in the habit of reviewing those, you know, at least once every 2 years.
Okay.
Yeah.
And should a new employment agreement be signed each time there's a role change, or there's a slight change in their roles and responsibilities, or is an addendum or a, you know, variation appropriate?
A variation of terms and conditions is fine. Obviously, it just needs to be in writing. You know, a lot of in every employment contract there would be an express term, and to be honest, probably every contract that any variation to the agreement needs to be in writing and signed by both parties. So it doesn't have to be a totally new employment contract. It can just be, you know, a variation of terms and just varying the specific term that needs to be varied.
Okay. Yeah. And I think the last point to that is from a legal perspective, can employers make changes to existing contracts? So, you know, can they reduce hours? Can they do this without consultation?
Well, not without consultation with the actual employee. It can't be unilateral. It needs to be a kind of collaborative approach. And what we always recommend is that once there is agreement between the employer and employee, that the employer actually advises the employee to seek independent legal advice to do with these about the changes. So that, and whether or not they do, that's another thing. But the employer then gets the employee to sign a kind of certificate saying that I was advised to seek independent, just to make sure it's all above board. Because if you unilaterally change conditions to a contract or terms, you're exposed to a breach of contract claim for repudiating that contract. So, but always seek advice in these situations, legal advice, just to make sure that you're not exposed with those changes.
No, that's good. So just to kind of add to that, so a lot of small businesses don't have the benefit of a HR department, or, you know, normally that's probably the bookkeeper and the payroll person and the office manager as well as. So what are some of the things that, you know, from your perspective, that you've seen with some of these smaller businesses, that what they should be doing, or how do they manage that, you know, those changes and those legalities?
Well, a lot of the time, as you said, some businesses don't have the resources to kind of understand what their rights and obligations in certain situations. So, and that's when it becomes difficult. That's when disputes arise. That's when they're certainly exposed, because they just kind of do it on the vibe.
Yeah, on the vibe. It's the feel. It's the vibe. Yeah.
So, we'll say a lot over this seminar, but you should always seek advice in relation to these kind of situations, because otherwise it will turn messy, most likely.
Yeah, I think we've all got a story, and you've already done. I think we've all got a story. So, given the economic challenges that the businesses are facing, and we're now officially in a recession. So COVID aside, I mean, I think we've kind of explored most of that. For businesses to survive, is there an option for businesses to reduce salaries or benefits for employees? And again, I know that there's that conversation, but is there a legal requirement around, or what are the legal requirements if they do want to pursue that?
Well, see, anything can be changed in an employment contract if there's agreement. So, and there does have to be an agreement, as I touched on before. We just can't be unilateral. If an employer goes to an employee and says, look, you know, our revenues are down by so much, is it possible if you take a salary reduction? And the employee agrees, then great, put that in writing, change. Where it runs into trouble is when the employer doesn't want to do that. And in that instance, you don't really have any recourse to change the contract. Otherwise, you'll be repudiating the contract.
And again, that's where legal counsel is quite important to have.
Lawyers pick those kind of things. Yeah. But I notice benefits as well. So for stuff like bonuses, etc., they're usually in a well-drafted employment contract. They're usually in an addendum, and it's completely discretionary up to the employer. So they can say, look, this year we're not paying the bonuses for whatever reason. If the bonuses are a contractual entitlement, then again, you can't just not pay the bonus without agreement reached with the employee.
Yeah, it's quite tricky, and again, it's making
It
sure that
minefield.
you know what you're doing before. So, and I know I'm going to ask you, you're going to talk a little bit down it, but is it best to have that conversation before you have the conversation? Is it best to seek advice or some counsel before you start to have those, particularly for small businesses who don't have the expertise?
Yeah, for sure. And I think seeking that advice, you can be provided a strategy, because in the legal field, deal with this kind of stuff a lot. They would have known they know what kind of strategies that can be employed to start that conversation. Can even draft letters to send on letterhead where it just goes through an honest and open conversation as to why it's happening. And it definitely will assist.
Yeah, and I think you probably covered our next question, which is managing staff through that COVID-19. What we've experienced this year is unprecedented in terms of the working from home, pivoting really quickly around our IT systems. I mean, we were joking before we jumped on that this used to be a face-to-face, and you'd have that audience interaction, and so I think all businesses have moved and pivoted really quickly. What are some of the challenges that you've seen as a solicitor through this last 10 months in relation to COVID?
Well, the main issue that arises a lot would be, because it's such an unprecedented time. Employers sometimes forget that employment law still applies. The Fair Work Act still applies.
Yeah.
So, for example, around dismissals, the unfair dismissal protections still apply. The requirement for a genuine redundancy still applies.
Okay.
So, where employers are finding themselves in a bit of trouble is where they, because X reason, they sack someone, but because it's COVID, they think that's fine, that's fine. But they find themselves, the Fair Work Commission answering to an unfair dismissal.
Right. Okay. So is that something that has been that you're seeing? Or?
Yeah, for sure. Maybe not to the point of the Fair Work Commission yet, but I think that's going to rise there. For sure.
And just in that, so what about managing performance? So you've got again, you've got small businesses, they're struggling, they're trying to make a buck and keep afloat, and you've got staff that can't deliver or have and I think everyone agrees that when this first started, everyone was very diligent. They were at the computer and they were doing the work. I think now businesses are saying, right, a bit fatigued, without time to get back, and so now, in terms of performance, do you still have the right to performance manage staff through these kind of pandemics, or are they protected?
No, for sure. I think, and that because the unfair dismissal protections still apply, and the redundancy requirements still apply, you pretty much have to performance manage, otherwise you're going to find yourself in trouble. What was it? Something else. Something came to my mind, but I've just.
It'll come back to you. So it was more around the underperformance, and were you able to manage underperformance?
So what I was going to talk about the small business. So under the small dismissal code for businesses under 15 employees, it's a bit easier to let go of an underperforming employee. So
just tell us a little bit more about that. What's that? How is that different?
So instead of to avoid an unfair dismissal claim, you have to kind of performance manage in the sense where you have to give 3 written warnings and meetings, etc. Small dismissal claim is for businesses under 15 employees, which also reduces redundancy payments to nil. They only have to go through, the process for those 3 warnings, 2 warnings, it's kind of minimised into one. So this just makes it a lot easier. You just have to tell them have to have a meeting with a warning, and then obviously tell them that they're at risk of losing their job.
Right.
And then from there, dismissal.
Right. So there's not that laborious kind of process that can take months and months when you're part of a big organisation.
And I think that's the reason behind it. They want to make it more streamlined because small businesses need, workers that working.
Proactive, being proactive and active. And I think also too, in a small business, you tend to have everybody working hands on deck. There's no hierarchical there. So to be someone dedicated to performance managing staff, I would imagine that takes their productivity away from their business as well. So, okay, that's really interesting. So we're just going to switch a little bit. So we've talked a lot about the business and SMEs and employers and how they can manage, obviously, this challenging time and what's been going on. Employees are at the back of all of that. So I wanted to just touch a little bit on for employees. In ARAG, we have a really good product, which is a high net worth product, which we think is something that is really valuable to employees. But from your perspective, what are some of the challenges that employees now face?
Well, it kind of ties into what we've been talking about, but it's employees not knowing their rights around certain areas. So, termination or redundancy, or whether they have to agree to a change. So you see examples of employers kind of bullying, coercing employees into taking, salary cuts, etc. So problems arise around, employers not really knowing their rights and having kind of gun-ho employers who shoot first and then ask questions later.
Right.
Yeah, especially with high net worth, people over the high income threshold.
Which is?
I think it's around 153,000 each year. It goes up.
Okay. So they're protected under 154. Let's say rounded up, 153, 500, whatever. They're protected under Fair Work. Is that correct?
Yes. So they can make unfair dismissal claims. Okay.
So they have some level of protection per se. Yeah. Okay. Yeah. So over that, you're kind of on your own.
Yes.
And
there are still obviously legal avenues that you can challenge a dismissal. So whether or not it's a breach of contract claim, or there's general protection provisions under the Fair Work Act as well, which is just kind of general rights of employment. So if it's always worth at least seeking advice as to whether your dismissal is above board.
Or you're getting the entitlements, because I think
exactly
the thing I think is very quite scary is that businesses have closed down, and there's a lot of employees that may not, and particularly that 15 staff member and under, that small space, that maybe their entitlements haven't been paid, maybe their super's still outstanding, and maybe there's certain things that haven't been covered as part of the process, and I think that's an important part for most, like you said, to seek advice, or at least seek some sort of instructions. Are we seeing more of that? Are you seeing more of?
Well, I think we will see a lot more of it, especially while JobKeeper's around, where it's kind of everything's on a bit of a life support at the moment, and once JobKeeper does kind of cease, I think we'll see a lot more employment disputes over, time zone, etc. When that does occur.
Yeah, it's kind of a bit of a cliff we're heading towards, isn't it? You'll be happy. Okay, lucky last number 7. So I suppose we've got most of our brokers are on we've got a couple of direct clients on here as well, but we've mostly brokers, and I suppose one of the things I wanted to ask you is, what are some of the things that our brokers can help support their clients, and what sort of things could they be doing to protect their business from some of these disputes? And I know you've talked a little bit, but are there specific kind of checklists?
Besides legal expense insurance?
Well done. Yeah, but
so
and again, too, I know the big corporates do it really well, and you know they pretty much have it covered. They usually have an outsourced HR, or they have those sorts of things. But you know, for every day Joe Blow that's trying to just keep afloat and trying to keep, you know, the doors open and you know, the last thing he wants when he's been trying to do the right thing all the way through this is for someone to come in and say, you know, I'm taking a call from a dismissal.
Exactly. So I think what brokers, you know, they're usually the first point of contact for their clients. I think they need to just ensure that their clients are seeking professional advice when around these kind of real important issues. So when I know we're going to go into some case studies soon, but these are 3 examples where employers did come to and sought professional advice before they pulled the trigger on some stuff that would get them in a bit of trouble.
Right.
So yeah, seeking advice is always important. Yeah.
And having their own.
Yeah, exactly.
Very good, very good. So that's it. Yeah. So we might just jump straight into those, Jack. And I think part of these would be really good if we can. What you know, you're going to tell us about what the good outcome was, and what the mitigator was, which is great. But maybe what could have happened if it had gone to full fruition would be great. So I might hand over to you. So you want to talk us through this one?
Yeah. So this one was more a couple of months ago when the case rate was going up in Sydney a fair bit, and you know people were very worried. So it was more of a preliminary question asked by an employer as to, you know, whether or not if someone came in sick, displaying COVID symptoms, could they send them home? Could they force them to take a COVID test, and then could they be demanded to show them the outcome of their test? So this all kind of, our advice was, you know, it all kind of ties into what we what I touched on briefly before about that lawful and reasonable direction. And with work health and safety, the employer has the primary duty to make sure that their workplace is safe.
Yeah.
So a lawful,
and that's for other staff as well.
Yeah, exactly. So a lawful and reasonable direction to an employee that doesn't even have to be COVID, that is displaying, you know, sickness that could in turn make the other employees sick, then it's 100% a lawful and reasonable direction to send someone home. Can you make the employee take a COVID test? Now that's a bit more of a curly one, but for the same reasons, if you're basing it on you know, medical and government advice, there's symptoms, and you need to make sure that your workplace is safe.
Yeah.
A lawful, lawful and reasonable direction would be to ensure that they take a COVID test before they come back into the office, which ties into the last bit of the question, where can I make the employee show me the outcome of their test? Now there's a big privacy obligations under the Privacy Act to do with employees demanding health information from their employees, but at the same time, which is still untested because it hasn't, you know, been tested in the courts, whether those privacy obligations are kind of null and void when it involves, you know, the spread of a virus. So in our view, we would say that it was a lawful and reasonable direction that the employees show the outcome of the test, or at least provide a medical certificate that shows that they're fit to work. Yeah.
And I think that's probably the standard pre-COVID, isn't it?
Yeah, exactly. We ask for medical certificates for everything.
Yeah.
So no issue there.
Okay. JobKeeper.
Yeah. So this one was involved a travel agent who came to us for advice before it got really hairy, because under the JobKeeper scheme, for industries or for industries that had to shut down completely, essentially. So, airlines, travel agents, even hospitality.
Yeah.
The JobKeeper scheme allowed the employer to issue a stand-down direction, which means their hours are completely reduced to nil.
Mm-hmm.
They're kept on the books, but they're just paid the JobKeeper payment.
Okay. And that JobKeeper is different to JobSeeker, isn't it? Because they're still employed.
Yes.
Yeah.
Yes. So what happened was an employee, after about 2 months of doing nothing at home, found another job that was a bit above the JobKeeper payment and resigned from the travel agent. And a dispute arose because the employer, so our client, the travel agent, thought that the entitlements, as the employee wasn't actually working at the time.
She wasn't.
She thought, well, the entitlements didn't accrue over that time because you're just sitting at home.
And do they accrue?
They do accrue,
right.
And they accrue at the rate of what they were on pre-COVID. So
okay.
it was kind of a two-piece where, one, if entitlements did accrue, did entitlements accrue, and then second, what did they accrue at? And it's at the pre-COVID rates, which is important because for businesses to consider, because if you're on a stand-down direction, haven't worked for could be 6 months, and then JobKeeper finishes, that exposes you kind of financially because and then if you can't afford to pay those staff after JobKeeper finishes, you still have to pay out those entitlements that have been accruing at the normal rate for 8 months, but you haven't actually had any money come in.
Yeah.
So that's why you've got to kind of think of your exposure now as to whether or not you should be making these staff redundant.
So superannuation inclusive of that?
Yeah. So.
Wow.
Yeah.
So that's a big financial liability that businesses are sitting with right now.
Mm-hmm.
Yeah. And so, what was the outcome?
So we advised that because the employee was kind of picking up a stink as to not being paid their full entitlements, we advised the employer to pay it.
Yeah. Let's just knock that one over.
Yeah.
Okay. But it could have got messy.
Yeah,
it could have financially.
Sure. And it would have ended up being litigated, I imagine, if the or at least the Fair Work Commission.
Yeah. Which is that a costly exercise? I mean,
obviously the Fair Work Commission not so much because it's meant for Joe Block, the employee, to be able to bring the big employer to the Fair Work Commission. So it is quite cost effective, but the results aren't always the final.
Yeah.
Then it goes on to the courts.
Yeah. Well, that's something that this afternoon. So this one, talk me through this. So this is a salary reduction to a high income earner.
Yeah. So.
This be you, Jack. It's you.
So the employer was a client of ours who, due to COVID, had company-wide temporary salary reductions, which all the employees agreed to, until I think maybe January next year. And what that did to this employee is took it for say 170,000 to 140,000,
right?
Which takes it below the high income threshold. And the employer wanted to dismiss this employee, but sought our advice first as to whether or not that would she be protected under the unfair dismissal? Could she be under the high income threshold if you took it at the salary that had been reduced, or was she still a high income thresholdee, I suppose, because at a normal rate of salary she's 170,000, and there's another matter that's just actually been decided in the Fair Work Commission about this, is that the employee is, if she gets dismissed at their rate, at their current rate, so 140,000, then she would be protected under the unfair dismissal.
She would be.
She would be. So it was lucky, I suppose, that our clients came to us for advice before they pulled the trigger, because otherwise they would have ended up in Fair Work.
Fair Work, yeah. Okay.
Under unfair dismissal.
And that's because that is at the point of the dismissal, is the salary band. Okay.
Yeah. And as I said, that advice was backed up, I suppose, with a decision that very recently in the Fair Work Commission.
Okay, thanks, Jack. I think that, so we've had a couple of questions. So workers' comp and COVID, does workers' comp extend to the home if you're being directed to work from home?
So that's actually, it's a curly question. I don't actually think it's been tested yet. Certainly, employees still have that obligation of workplace safety to the home.
Yep.
But in practice, it kind of becomes difficult, because how can you ensure that they're working and operating safely?
Yeah, it's interesting. I read a piece a few weeks ago, and I think it was on the domestic violence. And what, I mean, obviously that's correct. That's a whole other issue. But where the employer had directed their staff to work from home, knowing that someone was in a volatile relationship, and it was classed, or it had been tested in the workers' compensation area at the moment. So, it's interesting that obviously through COVID, but also the way we start to operate differently.
Yeah,
it does change our laws a lot, and sort of keeps you in business.
Yeah, everything's adapting. Not even outside the legal industry, everything needs to adapt. It's such a crazy situation.
So what are some, I mean, we haven't got anything here specific, I'm putting you on the spot a little bit here, but because we've got through some time, but what are some of the things that you've seen go quite wrong? I suppose not just even through what we're facing at the moment, but where an employer has either not taken advice or could have sought advice, and then it's turned pretty nasty and ugly.
Well, a big one we're actually kind of working on at the moment, it's not necessarily COVID related, but it's where an employee was essentially bullied into resigning,
right,
and accepting further post-employment restraints that were incredibly unreasonable.
So you're acting for the employee?
For the employee in this matter. So, that's it's always around the kind of employee-employer relationship, because if it's messy, then people do make some pretty rash decisions. Yeah.
Do you think, in your experience and what you're seeing, are employers being smarter about that? Because you go back many years ago, and I think employers didn't think too much of it, particularly the smaller SMEs. No, I'm not talking about big corporates. Obviously, they're regulated, and it's they've got cottage industries around, all that sort of stuff.
Yeah.
But certainly the SMEs, there were some pretty horrendous stories that you kind of hear about or read about. Do you think that's kind of stopping or slowing down? Or are we getting smarter about how we treat our people?
Well, I'd like to think so. I think it's definitely to a lesser extent than it was, but you still do see a fair bit of it.
Yeah.
Especially in small and medium enterprises where the turnover of employees is a lot greater, I suppose. So you still do see a lot.
And so, obviously, if you're seeking legal advice is obviously key. For those that just want to get some general information, where should they go to, or what could they look to do?
Well, I suppose it ties in great with ARAG. Policyholders can get on the legal helpline for a free, no strings attached phone call for some legal guidance to a panel lawyer. That's one great way.
But if they're not a client, if they're, so what you're advising businesses now as they work through? I mean, I think one of your great call-outs was, let's get yourself organised, start planning, start thinking about what those financial liabilities are going to look like, so that you can then make some
employment decisions. It's not just about the bank decisions or the P&L decisions. You know, they're also a liability, for a better word, that the business needs to manage. Are there fair work sites? Are there, you know?
Yeah, so all those, there's a lot of government agencies that assist. So I think Fair Work, the fairwork.gov is a fantastic place to start. And you know, even the ATO website, all those kind of government websites have an abundance of information that's easy to digest and at least gives you a starting point.
Yeah.
So if you're still concerned, then you can take some further.
Yeah, no, I think that's good to know, you know, just as a general, and certainly for our brokers who are helping advise some of their clients, that, you know, we always know it's challenging to get them to shift the mindset, and it's, you know, it's not an issue until it is an issue. And certainly, you know, from our perspective, employment is a big part of our coverage that we offer in our business insurance. So, and we think that's a really valuable cover or event that we cover through our insurance piece, which is not only just for the business but for the private. So
yeah, no, for sure, I agree.
So we're just going to we've finished early on time. We've finished ahead of time, sorry. So it'd be great to get some questions if anyone has anything for a few minutes. If not, we can all let you have some 10 minutes back in your diary. No, I think we've covered everything. We had a few questions come through in the session which we threw in there, so I think we've pretty much covered. But look, if anyone does have any questions or you want to reach out to Jack, please contact us at contact@arag.com.au. And yeah, we'd love to hear from you if you're from a broker perspective. If you want to know a little bit more about our private product or our business product, please give us a call. And thanks for joining us this afternoon. Cheers.
Thanks, guys.
Thanks, Ray.